Hello everyone, I'm Advocate Upasna, in-house counsel at Law Offices of Kuwar, VIVEK Tanwar, Advocate and Associates. Today we are here to talk about whether a person who fails in attempt to suicide deserves punishment or should be treated with care. The increasing number of suicide cases in India has highlighted the unheaded issue of Section 309. The suicide of late actor Mr. Sushant Singh Rajput has compelled the society to think about the issues relating to mental health. In India, the laws are quite stringent on suicide. One of the most archaic laws on suicide is Section 309 of Indian Penal Code, which punishes the attempt to suicide with maximum 1 year of imprisonment. So, a person who dies by killing himself cannot be prosecuted. But a person who fails to commit suicide can be punished under Section 309 of Indian Penal Code. It is not the first time when the constitutionality of Section 309 of IPC has been challenged in the four walls of the courtroom. Article 21 of the Indian Constitution provides and protects right to life of an individual, where on the other hand the Supreme Court observes that scope of Article 21 is not big enough to cover the right to die. The constitutionality of Section 309 was first challenged before the Supreme Court in P. Rathinam vs. Union of India, where the court observed that Section 309 is irrational and violative of Article 21. Hence, the court struck down Section 309 of IPC on the ground of it being unconstitutional. But Section 309 did not remain in the dark cloud for so long. The constitutional validity of this section was again challenged in 1996 in the case of Gyankur, where a larger bench clarified that Article 21 does not include right to die. Hence, Section 309 does not stand struck down as late in the above mentioned cases. After witnessing the increase in alarming number of suicide cases and to comply with the UN Convention on Right of Persons with Disability, the Indian government passed a Mental Health Care Act 2017. This act minimizes the impact of Section 309 of IPC as it provides a presumption of severe stress in favor of those persons who attempt to commit suicide. The Mental Health Care Act does not repeal Section 309 of Indian Penal Code, but rather provides a presumption in respect of mental illness. In case Common Cause vs. Union of India in 2016, the Supreme Court reaffirmed the judgment of Gyankur and held Section 115 of Mental Health Care Act is a non-obstantive provision which mandates that a person who attempts to commit suicide shall be presumed to be suffering from severe stress unless the contrary is proved by the prosecution. Recently, a writ petition is filed before the Supreme Court to challenge the validity of Section 115 of the Mental Health Care Act. At last, life is a gift given by God, and this precious gift is protected by Article 21 of Indian Constitution, as Indian Constitution does not consider right to die as a part of right to life, whereas the enactment of Mental Health Care Act 2017 has significantly reduced the impact of Section 309 and has virtually made an attempt to commit suicide punishable only as an exception. That's all for today. I hope you all have liked our podcast channel. If so, then do please subscribe our channel Noble Litigators. Thank you and have a good day.